So good morning to all of you who have joined us this morning for another webinar within the HR Just Empirical webinar series, and also to all of you who will watch this video because it's being recorded later on. My name is Veronika Bielkova. I am a senior researcher at the Center for International Law at the Institute of International Relations in Prague in the Czech Republic, and I will be the moderator of this event. Today we have the honor to have with us a really distinguished speaker, and that's Professor Martin Scheinin. I do not think that Professor Scheinin needs a lengthy introduction, but I will still say a couple of words about him at the beginning, then we will go through some housekeeping rules, and then we will start with the presentation. So originally, Professor Scheinin comes from Finland, and he started his impressive career as a professor of constitutional law at the University of Helsinki, and also as the professor of both constitutional and international law at the Åbo Academy University in Turku, also in Finland. Later on, however, he has left Finland, at least for the major academic involvement, and now he's been mainly affiliated for almost 20 years with the European University Institute in Florence, where he is a professor of human rights law. At the same time, he is also a professor at the Lund University in Sweden. And internationally, though, also this is also obviously an international part of his career, but he was between 1997 and 2004 a member of the United Nations Human Rights Committee, where he, among other of his achievements, he was one of the main drafters of one of my most favorite general comments, and that is General Comment number 29 about the states of emergency. He was also the first, if I'm not mistaken, UN Special Rapporteur on human rights and counterterrorism. He was the member of the Scientific Committee of the European Union Fundamental Rights Agency, as well as the president of the International Association of Constitutional Law. And I could go on and on with other important positions he has held throughout the years. Obviously, as an academic, he has also authored or co-authored many important publications, books, articles, reports, mainly in the area of human rights. And if you want to learn more about Professor Scheinin, he has a very detailed profile on the Wikipedia. I already mentioned it's quite unusual for a legal scholar to have such an impressive and lengthy profile on the Wikipedia. Normally we find that for politicians or for like rock stars, so he's definitely an international legal star. I've also learned a lot about his political career, which is quite interesting in this profile. But today, Professor Scheinin will share with us his conclusions or his findings from empirical research. More specifically, he will present the different models of relying on empirical facts in the assessment of human rights compliance. So his lecture is entitled Facts and Norms in Human Rights Assessment. Can human rights compliance be measured? And we are very interested in hearing the reply and the explanation for the reply. Before that, a couple of housekeeping rules very shortly. So we will first have the presentation with a PowerPoint, and then we will immediately open the floor for questions and comments. So please, if you have any questions and comments, you can either, and that would be the preferred way, include them into the chat so that we can go through them also in the written version, or you can obviously also raise them already once the presentation is through. Having said that, once again, many thanks, Professor Scheinin, for being with us today, and you have the floor for your presentation.
Thank you, Professor Bielkova. It's a pleasure to address this audience of the HR Justifications project. And I know that you are running a series of empirical webinars, and I'm trying to meet that challenge by addressing the question, can human rights compliance be empirically measured? As to the biography, it is relevant for this presentation because I'm going to go through several iterations of human rights assessment during my long career. So there will be a little bit of looking back into the CV, but I do want to mention that I haven't written my Wikipedia page. There's a history behind. It's a battleground between friends and foes, and that's why it looks perhaps a little bit strange. Let's go on with the presentation. I will share my slides. There you are. Well, can human rights compliance be measured? And I'm going to refer to 5 different iterations during my career where I have been looking into this question. And one line of evolution over those decades has been moving. Do you see my slide?
It has disappeared now.
It disappeared. Sorry. I need to stop there. I need to go back to Zoom. I need to share. I must have pressed the wrong button. Share. And full screen. New try. So here's a list of reasons why I want to address the theme to this audience. HR just. Maybe the main lesson I'm trying to deliver is that there's a lot of mistaken uses of legitimate aims as a justification for human rights intrusion. And my main message, one thing you take home today, is that evoking a legitimate aim does not count as a justification for restricting human rights, even violating them. Even when applied in good faith, the legitimate aim is merely one element in a process of justification, and we need to go to empirics to see whether the justification actually is proper. Invoking a legitimate aim kind of ties your hands. When you have said, I restrict human rights in order to reach this legitimate aim, national security, typically, then you must stick to that aim. And then your conduct will be measured against how you deliver towards that aim. What else is needed for justification? I'm advocating for a structured framework of what I call the grammar of human rights law, meaning the structures, principles, concepts of human rights. Often it's an analytical list that you must go through in order to tick all boxes, to check whether all elements of the justification are there. Many of them are empirical in nature. Academically, I am ambitiously striving for a general theory of assessing human rights compliance, some kind of common framework for assessing permissible limitations upon human rights, usually negative human rights obligations in relation to civil and political rights, but also positive obligations, which usually are not subject to equally rigorous analytical frameworks. Typically, positive obligations relate to economic, social, cultural rights, but there also, I think there should be more structure, more rigor, more analytical frameworks of concepts. Further, in my view, the prohibition against discrimination, even if it's very well established in human rights law, is still under-theorized in the sense that when you read presentations, even thick books by experts about the prohibition against discrimination, they may end up in a fairly simplistic explanation. What's objective and reasonable differentiation is not discrimination, is not prohibited. I think, again, we would need more tools, more concepts in order to be able to measure whether differentiation amounts to discrimination or not. And finally, collisions between human rights. Typically, different rights of different individuals. Also, these situations can be resolved through an analytical framework, which would be based on quantification, measuring, in order not to do abstract balancing, but to do concrete assessment of a framework of different parameters. Two points that I want to emphasize in this possible future general theory is the importance of the primacy of the essential core of any human right, be it a question of restrictions, positive obligations, or collisions between human rights. The essence of any human right must always have primacy in relation to non-core areas of other human rights. And there are categorical differentiations, and that's why I truly believe that in human rights law we need also hard and fast rules, so-called red lines that must not be crossed. There is an essential core, not only in non-derogable rights, but in all human rights. Outside that core, it becomes important to be able to measure, because there we truly have space for what's called weighing or balancing. I call it measuring or reconciling through combining the different features which speak for or against giving primacy to a particular human right. That relates to the non-core areas. And from the central role of empirical information, I believe that we also should be working towards a new human rights epistemology. What are the epistemic benefits of human rights measuring? Because it gives us new knowledge about what human rights are, how they are operationalized in practice, and how these various situations of tension are being resolved through measuring, through empirical information and its quantification. I mentioned that there's been 5 iterations, and Professor Bilkova mentioned some things from my past. And I have marked the first one and the last one in a different color in this list of 5, but I'll focus on the 3 black letter ones in the middle. But I mentioned first, indeed, I was a member of the United Nations Human Rights Committee, which is a treaty monitoring body assessing compliance against the Covenant on Civil and Political Rights. It was an interpretive function. It was a good job for a legal positivist to take a treaty, the Covenant on Civil and Political Rights, and assess states' conduct, whether it is in compliance with the treaty provision or not. And many experts doing that job, of course, are lawyers, and they think they develop an intuitive sense. I know a human rights violation when I see one. I just compute within the database which is in my brain, and I can tell, is it a violation of the ICCPR or not? I think that is a fallacy. It's not intuition. It's not pure legal expertise. It's also experience in practical application of the norms. And here we come to empirics, and I will explain it soon. The last of the 5 on the list is my current affiliation through the European University Institute, EUI, in a Horizon Europe project called Eloquence. Eloquence is a project of the current artificial intelligence age, which develops multilingual, multicultural context where AI applications such as chatbots or call-in services provided through AI that are compliant with fundamental rights and other European values. And our job, the job of the EUI team in that project, is exactly assessing compatibility of what the technology partners develop in Eloquence against compatibility with European values, and we do it through 5-member multidisciplinary expert panels. And that work builds upon the 3 earlier steps that I will now get into. After the Human Rights Committee, I chaired a long process with the United Nations Office of the High Commissioner for Human Rights to develop human rights indicators. I'll speak about that first. Then I was a leader of a EU-funded project called SURVEILLE that assessed surveillance technologies for their ethical issues, legal limitations, and efficiency, including technological utility for delivering better security. So it was a different framework for human rights assessment. And then the final one, number 4 in the list, the third one of those that I will address more closely, was a brief research project at the EUI where we assessed compatibility with human rights of strategies against COVID-19. All in all, these are 5 iterations of thinking about human rights assessment, where the role of empirics has been different, but more or less increasing all the time. Now briefly about the indicators project. We worked several years with the Office of the High Commissioner for Human Rights, with statistical agencies, other international organizations, and then members of the treaty bodies to develop indicator charts for selected rights. We ended up covering 16 rights from the Economic, Social, Cultural Rights Covenant and from the Civil and Political Rights Covenant, selected so that quite comprehensively they cover the scope of the Universal Declaration of Rights. One lesson was that it's extremely complicated, but possible, to identify statistical categories and come with qualitative and quantitative empirical data to be used as being indicative of whether there's compliance with a particular treaty provision or not. But it was so complicated that one can say it's also impractical. There needs to be a role also for the treaty body experts. Some call it experience, some call it expertise, some call it intuition, how they then deliberate and discuss whether there's compliance or not. But indicators through empirical information does the groundwork to provide a common basis for those discussions. This chart summarizes just one example of compliance with a treaty provision. You see that there are 3 types of indicators in the left-hand column: structure, process, and outcome indicators. Structure indicators are structural preconditions for human rights compliance, such as ratification of a treaty, provisions in the Constitution, existence of specific legislation to implement the human right in question. Process indicators are then about policy. Are we making progress? Do we have programs in place? Do we have monitoring in place? Is the state capable of making progress and measuring its progress towards complete compliance? And then the final part is outcome indicators, which are in one sense the most important ones. They are about human rights delivery on the ground. And here we measure how human rights are delivered at grassroots level. Are there violations? Are there reports about violations by individuals, grievances? What are the statistics about prisons, violence, censorship, etc.? Concrete empirical numbers, which are not decisive, but indicative of compliance or non-compliance. These 3 types of indicators were then cross-referenced against what we called attributes of each human right. Through the general comments of the treaty bodies and other interpretive material, we distilled from each treaty provision 3 to 5 substantive areas, which we called attributes. And they depend on what right is in question. But we could then identify the indicators separately, not only for the right, but quite often for each attribute separately. And in all, we get to about 45 indicators per right. Extremely useful, extremely complicated and challenging. It does help the treaty body experts in assessing compliance. What is nice about the complexity is that you do not need to fill every box. You don't need to have the numbers for 45 indicators. You have what you have, and you fill the chart to assist the treaty bodies, and then they already give you an indication. Indicators are not decisive about compliance. They are rules of thumb. They point you towards further questions, they point you towards deliberation, and they point you towards treaty interpretation. So that was my first big experience of working with empirical data. We aligned this project quite carefully with statistical agencies in order to use as much as possible existing readily available statistical data, and not to ask for impossible statistics from the states parties that were reporting to the UN human rights treaty bodies. We dismissed a perception that the treaty bodies or their functioning could be replaced by simply looking at empirical information. No, quite often. For instance, a numerical quantitative indicator comes with a bell curve as a result. Very small number is bad, very high number is bad. And in the middle, there's a wide area where you can get indications of the value, but not a decisive outcome. For instance, complaints about torture in police detention. If the number is 0, that's something to look into very carefully and ask for other sources of information. As the number is very high, that's obviously a serious sign that there is torture. And if we are in the middle, then you look whether these cases were investigated properly, whether there were remedies, whether there were sanctions in respect of the perpetrators, etc. Next exercise was the SURVEILLE project. And here we went into multidisciplinarity. We have the benefit of the treaty bodies, namely multi-member expertise, but we did it here in the form of 3 separate panels. One for technology assessment by technologists, including also social scientists, engineers, economists. We had an ethics assessment by philosophers, and we had a fundamental rights assessment by lawyers. We made a very fine scale with 20 different factors for the technologists to assess the security benefit or other utility of a surveillance technology. So we used half points, so you could get between 0 and 10 points. As to how a particular surveillance technology delivers better security in a context. We used scenarios to test the usability of different surveillance technologies in different situations, and the technologies assessed whether it is indeed possible to get a security benefit through the use of a particular technology. So they had a 0 to 10 point scale, and it was discussed between the technologists who were multidisciplinary as such, but without us lawyers, for instance. The philosophers refused to give numbers, numerical scores. So they developed a traffic light scale, red, yellow, green, based on the idea that ethics doesn't give you categorical answers. It gives you questions, where to look, and then it gives you reasons to consider that there's a problem. A yellow light means watch out, be careful, there may be something wrong. Are you really sure that you want to do it this way and use this surveillance technology? Green is, we see no problem, go ahead. And the red, of course, is a no-go, but in the ethical sense of strong concern. The lawyers used Robert Alexis' weight formula, which basically multiplies the importance of the fundamental right in question in the situation by the depth of the intrusion. And we use the triadic scale 1, 2, and 4. 1 times 1 is 1, 4 times 4 is 16, so we came with a 16-point scale. Intentionally, the scale is longer than the technologist's scale. In technology benefit, the maximum is 10, but in the legal assessment, the scores 16 or 12 were reserved for situations that involve the core of a human right. When there was an important aspect of a human right and very deep intrusion, we interpreted it as a situation where the essential core is being breached, and hence no security benefit can justify that kind of intrusion. So it was a pragmatic numerical way of including the inviolability of the essential core. After these three parallel expert panels, we have a holistic overall assessment, which represents the deliberation by a treaty body where the different experts discuss, coming to a final scale, final score, and if needed, then going to a process of revising and reassessing. And by this feedback loop, introducing changes to the use of the surveillance technology or the details of the technology to lower the fundamental rights intrusion scale, often in relation to third parties, innocent third parties, which often was the main problem, or to get a higher technology score. So there's a inbuilt privacy by design loop in this model. Multidisciplinary expert panels, but separate assessment in discipline-based groups, and then a common framework for reconciliation. I think we made quite good progress in explaining how surveillance technologies can be measured, quantified, and compared in order to select in different scenarios the one or the selected ones of surveillance methods that would be delivering good level of improved security without unnecessary level of human rights intrusion. Incidentally, I need to mention that we, of course, tested this in respect of the Snowden revelations and the methods of electronic mass surveillance, and it was very reassuring to get the result that the fundamental rights intrusion was very high levels, often even 16, because of the adverse effect upon innocent bystanders, while the technologists could give only quite low scores, in the range of 5 out of 10. So in a sense, the SURVEILLE project proved through empirical quantification and assessment that downstream communication surveillance fails, because you are not starting from a suspect where you know that either here or in the vicinity is the needle in the haystack you're looking for. You are starting from the hay and hoping that you end up with some needles that you find from the haystack, and you bring more and more hay in the hope that you would find a terrorist. This is a foundational problem with electronic mass surveillance, which is downstream in the communication flow. The success stories of electronic surveillance actually relate to situations where there was already a suspect. no proof of guilt, but there was a suspect, and then they used upstream surveillance, the same method of electronic surveillance, but targeted so that it was based on a suspicion whose communication networks were then examined. For that kind of situation, the SURVEILLE project would give a much better score, so that the technology score would be higher and the fundamental rights intrusion would be lower because of not surveilling innocent bystanders unnecessarily. The third project I want to mention was an effort in 2020-2021 to find a holistic human rights assessment compliance method for assessing countries' strategies against COVID. This was done at the EUI. It was not a multi-year project with big funding. It was a short, more of a pilot to develop a methodology, and again brought up new aspects in the overall theme of human rights compliance assessment. This time we wanted to look at all human rights. We had 4 baskets: economic, social, cultural rights, civil and political rights, equality and non-discrimination, and finally a basket called rule of law, which is structural issues such as access to justice, lack of arbitrariness, and no abuse of emergency powers. So these were all given equal weight in respect of human rights compliance. And already this is novel, because much of the discussion on human rights and COVID-19 was about civil and political rights and the restrictions. And when you do focus on those restrictions, you easily get a one-sided picture and you don't know what we are comparing the benefits and the demerits against. Within each basket, we had then weighting, so that in the economic, social, cultural rights basket, or maybe more appropriately, positive obligations basket, we had a big place for the right to life, accompanied, of course, by the right to health, where we used COVID deaths as a main indicator. In the civil and political rights basket on negative human rights obligations, we had 3 selected proxy rights: freedom of movement, privacy and data protection, and freedom of assembly, coupled with other political rights, where we applied the permissible limitations test in respect of the restrictions introduced through COVID. And in the equality and non-discrimination basket, we focused on vulnerable groups, but also looked into gender aspects and the lack of arbitrariness. Finally, in the rule of law, emergency powers were one important aspect to look into, as well as the requirement of a legal basis for all measures and the access to remedies. Each basket could result into a grade from between 0 and 100. But now the crucial point was that in order to pass the overall assessment of a strategy being human rights compatible, you needed to get a passing grade from all 4 baskets, over 50%. Only if you got minimum 50 points from each basket, you could then have an overall score, which was the average of the 4 basket level scores. And we just to illustrate said that anything from 70 points upwards is best practice, anything above 60 is good, and anything above 50 average is a pass. We tested this approach through a pilot study of 19 countries. The weakness of our pilot study was that often we had to rely on one country expert, which then deprived us of one of the key parameters of human rights assessment, namely multi-member panels and deliberation. So we couldn't avoid subjective prioritization by individual persons, so this or that's right aspect, and therefore the results we got for different countries were not totally comparable. But interestingly, we got very clear results that certain countries prioritized right to life and right to health, and introduced severe restrictions on civil and political rights, resulting in a below 50 grade from pillar basket 2. Other countries prioritized the civil and political rights and were very hesitant to introduce any kind of restrictions upon them, often resulting in high numbers of death and illness, resulting in a low grade from pillar 1. Or ignored vulnerable groups and their rights, resulting in a low grade from basket number 3, and therefore failure of the overall strategy to comply with human rights. We did even rank countries. At this point, I don't want to mention the winners, because we quickly realized that this was very time sensitive. We looked at the second half of 2020, meaning during the phase which was after the immediate emergency from March 2020 onwards, but where there were still severe restrictions in place and awareness of seeking to prevent contagion until the vaccinations kicked in. Our ranking was totally based on that specific period of time. If we had continued using the same countries and the same empirical parameters, we would have got very different results in 2021, because clearly some countries had COVID combat fatigue. They were quick to relax the restrictions on certain civil and political rights, such as freedom of movement and right to privacy, without waiting for the vaccinations to kick in. And other countries kept the restrictions in place and managed to keep their death toll quite low compared to others. So in a sense, our empirical results prove that comparison between countries and even ranking is possible, but one would need to have multi-member panels, and one would need to have also the time factor adjusted so that one would not be looking into one specific period of time, but a longer sequence of the whole pandemic. So this was the third iteration I wanted to mention, and I'm arriving at certain ground rules how to do empirics-based human rights assessment. Primarily through the COVID case, I would say it's important to include all state obligations under all human rights of all people. That's exactly what we tried to do in the COVID strategies assessment. And this reflects the interdependence and indivisibility of all human rights. Human rights assessment should never be only about civil liberties or negative human rights obligations. It should look into issues such as the right to life, economic, social, cultural rights, non-discrimination, the right to security of the person as human rights. And one needs to give due attention to the positive human rights obligations of the state. There is no big benefit of measuring human rights compliance merely looking at restrictions and whether they are permissible. If one fails to look at the other side of the coin, how are human rights delivered through legislation, through budgetary measures and positive programs to help those whose human rights are enjoyed to an unsatisfactory level. Second ground rule, because quite often human rights, when all human rights and everybody's human rights are taken into account, will be on both sides of the equation. There will be a need for reconciliation between human rights. One should avoid blunt prioritization. One should avoid an objective order of values and rather go for reconciliation, the optimization of delivery of every right, and that should be concrete in nature instead of one of abstract choice between one or the other right. Of course, this includes there's no compromising of non-derogable rights, such as the right to life or prohibition against inhuman treatment. And as I said in the beginning, every human right has an inviolable core, which should be given primacy within that core area in relation to competing human rights or competing legitimate aims that justify some restrictions, but not all. The principle of necessity is important and should be addressed properly. Human rights intrusions should be limited to those that actually deliver significant and measurable results towards the legitimate aim and are measures that cannot be substituted by less intrusive alternative without losing the benefit towards the legitimate aim. Only then is it necessary. And here we get back to the tendency of many governments referring to national security as a legitimate aim that justifies human rights intrusions. They do not go through all elements of the necessity test. They just say national security is a truly important societal goal. Tell us, how are you delivering national security through this measure, which entails human rights restrictions, and why cannot you find an equally good method to improve security without those human rights restrictions? After the necessity test comes still the proportionality test, which should be seen as a structured proportionality test. What is the measured benefit towards the legitimate aim, such as national security, and what is the measured human rights intrusion? Which one is greater? This is the ultimate step, the proportionality in a structured fashion, not putting against, for instance, privacy and national security, but the privacy intrusion as unavoidable is put against the actual security benefit that has been proven. Finally, human rights assessment must be evidence-based. We need indicators, we need measurement, we need quantification. But as such, numbers don't give us the answer. There needs to be a structured framework that gives context and correct role for each factual element. We need multidisciplinarity because of the combination of empirics and normativity. Interpretation is an important part of the process of assessing human rights compliance, but it should be based on best possible empirical data and its multidisciplinary compilation. So I have been speaking for legal positivism and even philosophical positivism in the sense of measuring and emphasizing empirical data. This is all appeal to facts and reason, hoping that societies would be ready to commit themselves to rational decision making in a world where everybody's interests matter and there's common accepted framework for a rational and evidence-based discourse. The good news here is that the digital information age gives unprecedented preconditions for this. Finally, we could live in a world where empirical data is available, is categorized, and is analyzed in a manner which gives a basis for evidence-based governance. I think that might result in a new approach to courts and judging, in the sense that there should be more emphasis on mixed multidisciplinary expertise instead of trusting the interpretive skills of a judge. Quite a lot of judging has been based on proxy reasons in the absence of actual empirical data. A more involving expert process, which is multidisciplinary in nature, could work in a different way. However, what I'm saying here is about an ideal world, which doesn't exist at the moment. Unfortunately, the world is moving in the opposite direction. Politics of today is burdened with prevailing views that neither facts nor norms matter. Truth doesn't matter, suffering of individuals doesn't matter, rights or the Constitution do not matter at all, humans and their rights do not matter in governance. And my final conclusion, therefore, is that even if I emphasize empiricism and even philosophical positivism, it's even more important that there would be commitment to norms, be they called law, values, or human rights. This is where our world is failing right now in modern societies. And therefore, I close with a picture of the house of cards, which is falling down. That's my general theory of human rights assessment. It would be great if we could live in a world where there is multidisciplinary expertise, combining sources of empirical data and then coming to a rational decision-making process. But that's not enough. We must have also the commitment to a normative basis where human rights have a central place. Thank you very much.
Thank you very much. That was super rich and super interesting. It was actually, at least from my perspective, more than I expected, because it was not only about empirical facts or the assessment of empirical facts, but also basically an attempt to construct a new theory of human rights and to suggest a new approach to human rights assessment. For the moment, I don't see any questions or comments in the chat, but the floor is obviously open for questions and comments. We have about 15 minutes left today. So please, if you have any questions, either write them into the chat or just raise your hands virtually or physically. We will see you. If this is not the case for the moment, let me start maybe with the first question, which responds to the last part of your presentation. You mentioned and called for an increased role of experts, not leaving everything to judges. But we saw, for instance, during the COVID, that very often experts are uncertain. So there is this scientific uncertainty. So how should judges deal with that when they should decide a case, but at the same time, and they consult experts, but different experts tell them different things, and there is this scientific uncertainty. I know it's a broad question, but just some hints, some ideas about that would be very useful, and I'm sure in the meantime, we will get other questions.
My answer was hidden in the position that the new digital information age gives us the epistemological preconditions for measuring and knowledge. And I think the COVID-19 case is a sad one in the sense that the epidemiologists, they came with centuries-old dogma. And then when they were challenged, they started to use legal terms such as necessity and proportionality. So I felt that the actual expertise was missing. And where I had great hopes was the real time flow of information through through internet-based services, Our World in Data, which could give immediate data on, for instance, how and what kind of restrictions work and what kind of restrictions don't work. Does closing of the borders work? Does internal barriers within a country work? How do the privacy restrictions and closing of schools, and what are the actual outcomes? And with a virus and a pandemic, we have the data for the basic contagion mechanism. And one could have a data-based monitoring mechanism that would work. I was here in Italy during the time of COVID, and I saw that in the Italian authorities did have a data-based approach, which was promising, and they managed to stop the downward spiral in the situation. And maybe this is one of the reasons why I then thought that this project is important. But overall, I was very disappointed how little the world learned, and the centuries-old dogma of epidemiology developed by empires to protect the emperor had such strong support within the community, which was called the experts, often the governmental infectious disease expertise, that kind of people were closing their eyes for the actual empirical data. So I don't think I was proven wrong. I don't think I was proven right, but I was disappointed how little was learned.
I think it goes back to your previous comment that we might have ideal schemes, but if we don't live in an ideal world, it's very difficult to put them into practice. For the moment, we have one technical, and now there is another question which is substantive. So the technical one is whether it would be possible for participants to receive the presentation. I would join this question, and it would maybe elaborate on it a bit more. So it would be really great to have the presentation, and it would also be really great to know whether the results of all these empirical studies you did are public, especially that on COVID-19. I have been already able to find the indicators under the UN, but for instance, for the COVID-19, where you assess different states, is this something that is public? So that would be a technical question or questions. And then now we have also a substantive question. So I will read it out. It comes from Fatima Karimli. How important are the roles of experts in so-called mixed regimes, where the state is authoritarian but includes some democratic elements? And how is the reliability of national experts assessed in such cases, taking into consideration that their safety can also be under threat? So I think it continues more or less in the discussion we have already started.
As to the practical question, yes, my slides will be available, and let's agree that I will add one more page with links to those projects so that we have the key results in the form of internet links. And this question from Fatima Karimli, I think integrity is the answer. Integrity is a quality of experts, be they medical, statistical, or legal, or other experts. It comes with professional ethics, and it requires courage. It's not a silver bullet. Experts can be harassed, experts can be killed, experts can be pressed to compromise their integrity. But often there is a scientific community which is able then to emphasize the relevance of integrity, and there will always, or almost always, there will be individuals who stick to their integrity and speak the truth.
Thank you. And
maybe I add here a bit of a reflection of the current situation in the United States, and that would simply be that The US has a very developed court system and an important role for judges. And it turns out that where we see now integrity is primarily in the judiciary to resist tendencies that are clearly in breach of the Constitution and legislation. But we also see that even that authority is questioned with reference to the fact that the courts do not have their own police or their own army. So the US is a very important laboratory at the moment.
Thank you very much. We do not seem to have any questions in the chat, so maybe if I may use or misuse my position, I have several questions, but I'll start with the first one, which is again a general one, because normally when we introduce these measurements, they are based on quantitative data, and they look impressive, they are very useful, but obviously they can also become kind of a mechanical automatic exercise which can distort the reality. So how to make sure that we do not apply quantitative data at the expense of, let's say, the reality out there? And that's a question that I think comes again and again, including in the assessment of the research, because that's again a question that is very relevant in many countries.
I would translate that question into a more simple one, which is, how do we know how far to go with the use of proxies? The Office of the High Commissioner indicator model is very complicated, with roughly 45 indicators per right, broken down to attributes and types of indicators, which secures that what you fear is not happening. And there's always very rich information if the whole chart is completed. But it becomes cumbersome, it becomes difficult, it becomes even impossible to do in practice. So then through experience, we start to see actually these three rights are indicative. And these 10 questions under those three rights are indicative. And it becomes a meta indicator, a rule of thumb that we can take shortcuts. And that's what we did, for instance, in the COVID study, that we looked into certain rights as representative of a whole category of right, and certain numerical values as representative, for instance, of compliance with positive obligations. It must be controlled. And I think there's a role for multidisciplinary expertise to have that discussion. Which parameters are the essential ones that actually work best in the literal sense, indicators, indicative of compliance, not conclusive, but indicative. And everything is then subject to deliberation between the multi-member expert body.
Thank you very much. And if I may have one more question, which actually brings us to the very first debate we had many, many years ago. When I first met you, I was drafting a thesis about fundamental standards of humanity, and you basically destroyed my thesis in the first discussion, which was very good. But now when you were introducing this new conception of human rights, it kind of rang the bell. There are some elements shared with this original concept of fundamental standards of humanity. So I wonder, after these more than 20 years, how you see the concept of the fundamental standards of humanity. Is it somehow related to the conception that you promote at the moment, or is it really something that you think was not a good way to take?
Fundamental standards of humanity, for me, that's 35 years ago, when I started with the concept. And it was a terminological innovation to address the presumed gray zone between peacetime and armed conflict. And still at that stage, it was 1990 to be precise, there were many lawyers who took the view that in times of armed conflict, we apply only the rules of international humanitarian law, and we don't need to look into human rights treaties. They have been proven wrong, I mean, normatively wrong up to the International Court of Justice. And there was a discussion that there are situations of internal strife or major public disturbances which do not meet the situation of requirements of an armed conflict, but where similar considerations apply. And then we would go through derogations under human rights treaties. And the question is the reverse: how does humanitarian law then influence the interpretation of human rights law? So it was I think, useful discussion that took us forward, and we have reached consensus, I would say, that inter armas silent leges is an incorrect position. Laws do apply also during armed conflict, and human rights do apply, but that human rights law needs to be interpreted in the light of rules of international humanitarian law. And the outcome is that there are fundamental standards of humanity that, irrespective of what is the legal source for the rights, will protect the basic preconditions of human rights, be it a situation of peace, war, or something in between.
So actually, there can be an overlap between the two concepts, in the sense that fundamental standards of humanity could be very close to this essential core that you mentioned in your presentation. Yeah,
I agree on that, yes.
And it seems also that the two conceptions, the original one and the one that you are promoting today, are actually responses to different challenges that we have seen in different historical periods.
Good.
I don't see any questions or comments in the chat. It's 10 o'clock, so we can, if there are really no questions, which surprises me, I don't want to keep asking questions just as a moderator. That's a bit of a misuse of my position. So if there are really no more questions or comments, then I would like to thank you once again for being with us today, for sharing the results of your fascinating research. I think maybe most of the people need to go through all these documents, and we would be really grateful for the presentation and the links, because I think for all of us, this has been rather new, and we need to familiarize ourselves with the documents before we will be able to formulate other questions. So thank you very much to you. Many thanks also to those who have joined us this morning or who will watch this recording later on. And I'm sure there will be other events within this HR Just empirical webinar series. So I'm looking forward to see as many of you in future, again, either online or hopefully also sometimes in person. So thank you very much and have a nice rest of the day. And thank you, Professor Shiny, once again.
Thank you. My pleasure. Take care.